Hi, everybody. My name is Patrick Droesch, and I'm the president of First Service Residential in the Dallas-Fort Worth area. And I'm pleased today to be joined by Clint Brown, shareholder in the law firm of Roberts, Markel, Weinberg, Butler, and Hailey. Clint is joining me today to have a conversation about the topic of rental properties in single-family associations and condo associations, as a number of you have asked us questions recently about rental properties in your associations, and what are some things that we're seeing, some areas of concern, some areas that you as board members may want to be aware of. And so Clint joins me today as we just have a conversation about these topics around short-term rentals, long-term rentals, and Section 8 housing rentals. And so Clint, as we get started here, obviously the first thing that we always advise our associations is to make sure that before they make any changes or considerations, that they work with a reputable, qualified law firm that operates here in the Dallas-Fort Worth area. So maybe speak to, as we get started here, the importance of using a law firm for conversations like this.
Absolutely, Patrick. And hey, thank you all so much for having me today to kind of chat a little bit more about some of these issues that have arisen. So I'm going to put my attorney hat on, give my attorney disclaimer. The information Patrick and I are going to be discussing today is for educational purposes only. If you really need some good legal advice, I strongly recommend you get with your counsel so that he, she, or they can advise the community on the specific issue that y'all are dealing with. With that said, I mean, why is it important to have an attorney represent a nonprofit corporation, a community association, whether you're single family or condo? It's important because attorneys love to put out a lot of legal jargon. Unfortunately, when you're working on an amendment to a document or the adoption of a policy, what may make perfect sense to you in terms of the wording may not work for your community documents or in the legal realm. So using one term of art in everyday conversations may be very different using that same word or term of art in the legal context. So it is important to have an attorney draft that governing document and assist y'all in the process. Now, should you just hire any attorney, or should you hire an attorney that specializes in community association law? And again, it's my opinion that it should be the latter. For instance, I'm board certified in community association law and residential real estate by the Texas Board of Legal Specialization. That basically means all I do is eat, breathe, drink, and write opinions on and for community associations. Why is that beneficial to an association versus maybe somebody who's just a general practitioner? And, you know, the first response I hear a lot is, well, Clint, your rates are higher than this other law firm who's general practice. And I get it. Yes, the rate may be a little higher, but when you look at the product you're getting, it's going to take less time for an attorney who specializes in the area to give you that opinion versus somebody who's more general practice. So what may take a general practitioner an hour likely will only take a specialist in that area of law, community association law, 30 minutes or 20 minutes. So even though the rates may, and I say may be a little higher, you're likely going to be paying the same amount or less. So, you know, it's just good to have that attorney, and it also helps you to meet your standard of care in being a board member.
So Clint, let's dive into the rental area. So many of our associations are seeing changes in the dynamic of their community. And most of these, they take their community obviously very seriously, and the residential part of their community is so important to them. And there are some growing concerns being expressed to us and to other management firms about the nature of increased rentals. Some of that is individual rentals, some of that is investor rentals, but we're seeing a dynamic change in the landscape of single family and condominium leasing. So can you speak to what you're seeing kind of across at the macro level, and then let's talk about the benefits and the concerns that might be involved in the different types of leasing products.
Yeah, so Patrick, really, really good question. And, kind of broad stroke look, this really came to light and really became a source of concern for a lot of communities across the state of Texas with the 2018 Texas Supreme Court opinion, Tar versus Timberwood. Very limited opinion in scope, but it in a nutshell says, hey, community associations can no longer rely on their residential use restriction to prohibit short-term rentals. So in a nutshell, associations prior to 2018 were basically saying, hey, Airbnb is a business use of the property. And because it is a business use of the property, it's not allowed because we are a residential use community, period, end of sentence. The Supreme Court knocked that idea down, that argument down, which, by the way, was supported by Court of Appeals opinions across the state. And they basically said, hey, because the Airbnb is doing residential type things on the property, it is not a business use of the property. That's the opinion in a nutshell. Unfortunately, a lot of folks read that opinion or maybe didn't even read the opinion, but started giving opinions that it prevented associations across the state from enacting any kind of short-term rental bans. And it just caused a lot of confusion. I don't know how many realtors I've spoken to and had to explain and correct them on the misinformation that was provided to them or that they obtained. Can we restrict short-term rentals? Yes, you can. Absolutely. No ifs, ands, or buts about it. It's the how to properly restrict that really is a question that you've got to answer, and there are some methods to do it. So there's amending the declaration or adopting or amending rules and regs. And I know we'll get into that here in a little bit, Patrick, but that's kind of the dynamic. And yes, we have seen a significant uptick in communities wanting to restrict those rentals because of all the issues you just mentioned, Patrick. And we're seeing some concerns, and we're seeing, property values being affected in certain communities that are not designed for this high rental type situation. So we are helping and giving some solutions to combat that.
Okay, so let's dive in here. If I'm an association and my declaration does not have a lot of specificity around rentals, what are my options as a board? What could I consider doing? And if I was to consider some form of change, what would I need to do?
Yeah, so two ways to affect change and to restrict rentals on some sort of level, and we'll talk about options. But the first type is to amend your declaration, your CC&Rs, your DCC&Rs, your deed restrictions, all terms of art meaning the same thing, your restrictions. That is the strongest way to regulate leasing. The second way is the adoption of a rule. A rule gets voted on by the board. Amending the declaration gets voted on by the owners. So obviously, way number one is going to be the more difficult path, but it is the stronger path that basically protects the association very, 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 very well. And getting into single family communities versus condo communities, there are, it's called the 67% rule. For single family communities, it's the roof or ceiling 67% rule. For condominiums, it is the floor 67% rule. So let's do single family first. So the ceiling rule, it is 67% of all owners need to vote to amend the declaration. If the declaration contains a higher percentage, let's say 75%, well, wait a minute, you've just gone past the ceiling because the ceiling is 67%. So the law says you've got to drag that 75% down to 67. So 67% is the cap. Now, if the declaration contains a lower percentage, let's say 50%, For single family communities, the law says you get to stay with the 50%. Why? Because we're just worried about the ceiling for single families. We're not worried about the floors. So single family, it is the ceiling rule for 67%. For condominiums, it is the floor rule. I like to think of condominiums, think of a mid-rise where there's floors stacked one on top of the other. So it's the floor rule. So if your declaration contains the 75% requirement of all owners, the law for condos says you stick with that 75. If, however, the condo declaration contains a lower percentage than 67, let's say 50%, the law says you drag that 50% up to 67 because it's the floor. 67 is as low as you can go. Those are the rules. There's a little more intricacy for condos due to, when your declaration was recorded, but that's a topic for another day, Patrick. That's the general rule of thumb.
So if we want to go with a policy change or a rule change, what does that look like and what's the standard?
So the first step most attorneys will do is look at your declaration. What does the declaration say? If the declaration, and we'll split it up between single family and condos, we'll do single family first. If your declaration says, hey, the board is authorized to adopt rules and regs regarding the leasing and occupancy of homes in the community. Let's say there's a deed restriction that says that. Well, then my opinion, assuming, all things being equal, I would make a good argument that gives us the rulemaking authority to adopt a leasing policy and restrict rentals. That's a specific rulemaking authority. The other type of rulemaking authority we see is what's called general rulemaking authority, where the declaration says something like the board of directors can adopt rules and regs governing the capital P property, which covers lots. That one, not as strong of an argument, but it is still an argument you can make that, hey, I have the authority to adopt leasing regulations. Again, assuming there are no restrictions on leasing in the deed restrictions, you only have this general rulemaking authority. That's single family. So that's how you adopt a rule that way. So if the attorney looks at it and we've got one of those general versus specific rulemaking authority, then the board may be able to adopt a leasing policy. For condos, you've got an even stronger argument that you can adopt a rule because of 82.102 of the Texas Property Code. That statute gives the board a number of powers, but one of the powers is the power to adopt rules regulating the leasing and or occupancy of units, and it goes on and on. But basically, you've got rulemaking authority as it relates to leasing. Assuming your condominium doesn't have anything contrary in the declaration on leasing, you may be able to hang your hat on that statute in conjunction with rulemaking authority in your condo declaration to adopt a leasing policy that way as well.
So as we think about time, so short-term, long-term, are there differences about the way that we would handle those from a policy standpoint?
Yeah. So, from a policy standpoint, absolutely. Short term, long term, that's a durational restriction. So you would amend the declaration or adopt a rule, assuming one of those applies to you that we just discussed, that limits the leasing of units to a certain period of time, 30 days, 15 days, 6 months, 1 year. So no lease less than 30 days, 6 months, 1 year, 15 days, whatever the case may be. That would be a durational limit on short-term rentals, which basically indicates that only long-term rentals are going to be allowed in the community. And I think, Patrick, the second issue that I get asked is, well, that's all well and good. How do we enforce the thing?
Mm-hmm.
And that's where First Service and First Service's team comes in, as well as third-party companies. There are third-party companies out there now that meticulously monitor Airbnb, VRBO, HOMAway, all the websites that allow for these short-term rentals, they monitor them, and then they give the community association a report based on what your contract provides, weekly, biweekly, monthly, whatever the case may be. And that really helps give the board and obviously First Service a great tool to effectively enforce that new leasing duration restriction.
The other thing that we've seen a little bit of an increase, and I thought we'd talk about it today, is the idea of this Section 8 voucher program, which obviously is a federally supported home rental process. Talk to me about Section 8. What is that, and if an association was trying to restrict that, what types of things would they need to consider?
Yeah, so let's just go through a hypothetical. So Association A amends their declaration that basically says Section 8 housing rentals are not allowed in the community. Simple one-liner, Section 8 housing not permitted. So the first question you've got to ask is this discrimination on its face? Discrimination on its face means it is basically treating a protected class differently than everybody else. And that's just kind of discrimination, disparate treatment, or kind of discrimination on its face. The protected classes that the United States has recognized include race, color, religion, sex, familial status, national origin, disability. So those are our protected classes. So question one, does this restriction violate one of those protected classes on its face? And the answer is no, I don't think it does. So then the next question you've got to ask is, well, the restriction, no Section 8 housing, may appear neutral on its face, but it still discriminates against a protected class. And that's the issue that we're running into with this sort of rule adoption. It is a disparate impact claim, unintentional discrimination where the policy is neutral on its face, but nonetheless discriminates on a protected class. And again, you would see an increase in the likelihood of discrimination claims made against the association, maybe because you adopted this Section 8 rule. And I want to preface this with, this is just Patrick and I speaking right now. If you have one of these rules or you want to adopt one of these rules, I strongly, strongly, strongly recommend you get legal counsel. Get advice on whether or not this rule is okay to continue implementing, or whether or not you should consider it at all. So get that legal advice from your attorney. He, she, or they should be able to help in that arena.
So it's a big topic, and we've talked about short-term, long-term Section 8 and making sure, that associations get good legal advice, from a reputable, certified in the state of Texas law firm. Is there anything else, Clint, that you would suggest that board members watching this today should think about or know before they consider any changes regarding rental policies?
Yeah, so Patrick, one other big leasing issue we see happening are these investors buying up 50, 100 lots or units if you're in a condominium and just turning a 10, 15% rental community into a 40, 50% rental community. And one of the best ways to kind of attack that issue head on is to place a leasing cap in your deed restrictions. So you place a cap on the percentage of units that can be leased within the community. So if we are a 100 home community, place the cap at 25%. That means only 25 homes can be rented at any one time. You create exceptions to the rule that can allow for a temporary increase over the 25%. If you're already over 25%, you can also add a grandfather clause where the units that are currently leased get grandfathered until you get below that percentage, and then you start enforcing it. That's one effective tool that I've helped communities utilize. And then you use the same third-party company for lease monitoring. and short-term rental monitoring, and then getting a copy of lease requirement put in place for condos. For single family, you've got to be a little more hesitant on what you can request for leases because of 209.016 of the Texas Property Code. And then the other option I see a lot of communities utilize is requiring a homeowner to own or reside in a home for a certain amount of time before he, she, or they can rent it. So they've got to live in the home for maybe a year before they can rent it. That will dissuade these bulk purchases by investors. And again, hardship exceptions. There are exceptions to the rule where a homeowner genuinely has to leave. They've lost their job, they've had to move because of their job, something along those lines. You can grant an exception, but the general rule will help to dissuade investors from investing in the particular community. Why? Because they've got to sit on the darn thing for a year and lose that income for a year. And we're speaking about this, Patrick, and I'm seeing more and more communities that are designed for investors, and I think that's okay. That's completely fine. We are really seeing a change in dynamics for community associations here in Texas, and those are becoming more popular, and that is okay. But for those communities that are not designed that way, and you've got your owners that want to see a change, those are some options for you. And then finally, Patrick, and you probably know this, but one of the best ways to really get an amendment to the declaration passed is educating your owners, having the town halls, interacting with them, canvassing your neighborhood. All those things can really educate and get a favorable vote if that is what you want to do. And look, if your owners come back with no, we want to be a short-term rental community, then you're going to be a short-term rental community. And again, that's okay.
Yeah, that's super helpful. You mentioned using third parties to track rentals. One of the questions we're getting a lot was, how do we track rentals? Because it feels very difficult. What information can we request legally? And is using a third party probably the best way to do that? Can you speak a little bit more on that?
Yeah, so what we've got is I'm looking at the new law right now, and for a single family community, 209.016 applies. And here is what an association can request. So you can request the contact info, including the name, mailing address, phone number, and email of each tenant who will reside at the property, and the commencement date and term of the lease. So there is information we can require the landlord to submit. And if the landlord fails to submit the information timely, and we have reason to believe that it is a rental home, and one of the ways to do this is you review the county appraisal district records, and if there is no homestead exemption attached, there's a high likelihood that it is a rental property. So you can use that as your start point, and you send them a letter saying, hey, we have record that you are renting the home. However, you failed to provide us with XYZ information. You have 30 days to do it. And if you fail to do so, you will be fined X dollars. And I found that to be an effective tool to get the lease information. For the short-term rentals, Patrick, as you mentioned, third-party companies do an excellent job of monitoring short-term rentals and giving reports to management and the board so that y'all can effectively enforce any sort of leasing restriction you may have in place.
Sure. Hey, Clint, thank you so much for doing this today. I appreciate your time. I appreciate your insights. I know the board members that will be watching this appreciate your thoughtful insights, what you're seeing across this rental area. It's a quickly developing, changing landscape in this part of community management. So it's so helpful to have your guidance and your thoughtful approach to this thing. And again, we'll just continue to reinforce to our clients out there to make sure they're working with their counsel, getting advice, and if you're going to make any changes, make sure that you're being very thoughtful and intentional about those. So Clint, thank you so much for being with us today. It was great to see you again, and I know our clients appreciate your thoughts today.
Hey, you're very welcome, Patrick. Thank you all for having me, and always happy to help.